Greetings, everyone. Welcome back from our short break. And if everyone is here, we would like to continue. But before we go on, please remember to give the video a thumbs up from now on. If you're joining us for the first time, remember to go to the first video, which is ruling paragraphs 1 to 14. You need to see 1 to 14 first. Before you can continue here. So remember now, you're going to give the video a thumbs up from now. Go ahead right now, share as you always do, and feel free to leave your comments in the comments section. And that goes for you to my peeps, my subscribers. Yes, you know that you're going to give the video a thumbs up as usual. And of course, I thank you all for your support and your kind cooperation, including your kind comments too. Yes, me thank you all for the bad one too. I get some beating too, from the comrades who come over. But, we over here at Jamaica 411, we have a job to do. And that job is to bring you the truth, especially when others are bringing you the lies. Yes, we need to straighten it out because as Black people, we are susceptible to lies. Yes, my peeps, lies are very debilitating to us, whereas the other set of races thrive on it and succeed. It will cause us to flounder and fail. That is because we are the people of nature, and nature is true. So, when we lie or believe lies, it has a very debilitating effect on us. So, whenever I hear people talking things that are not true, and especially if it is looking like it's getting ground, we over here must come and straighten it out. Otherwise, we could be damaging ourselves. Yes, man. Lies are a drug that damages our brain cells. Yes. So, anyway, let me not take up any more of your time. You didn't come here to hear me nattering about philosophies. Philosophies and what some people would say unscientific. But, experience and observation teaches a great deal. And, of course, knowledge. But before I move on, I would like to acknowledge the first to comment on the video next hearing set for January 7, 2025. And that award goes to Diplomat. I don't know if you're a Miss Diplomat or a Mr. Diplomat, but congratulations. Give him a clap, man. Thank you again, Diplomat. And for the last video, which was entitled The Ruling, paragraphs 1 to 14, Elijah Bell was the first to comment. So congratulations, Elijah. Give him a big clap, man. So thank you very much. I believe you're a gentleman, yes. And thanks to everybody else who commented. So we're now going to go into the ruling of Justice Althea Jarrett in the matter concerning Holness taking the Integrity Commission and their members to court. Now, to give you a quick background. So what is happening is that the investigator decided in his report to make a recommendation that the file should be sent to the FID for them to investigate what he called some strange movements that were going between Andrew Holness's three companies, right? It turned out that is only half the amount of money that he claimed that was going in and out of between the companies, right? So he's saying that they should investigate that. And that now means that Holness's statutory declarations will be further held up because they are saying in a letter that they sent to Parliament that they're not going to certify his declarations until the FID finished them report. And you could be talking about years because this investigation that they were doing took 2 years. So you can imagine. Naturally, Holness is concerned, so he decided now to challenge the report itself, as well as a special report where they claim that them sending the report or handing the investigation over to the FID, and them now certify thing until them get until they get the final investigation report from the FID. So that is what Holness is now challenging in the courts of Jamaica, and the only way he can bring a challenge is by judicial review, because that is what the law says. The IC put out a report, it's tabled in Parliament, you cannot get it reversed unless you go to the court, because the IC does not take instructions from anybody else other than the court. You understand now? Great. And so the judicial review now has 2 stages to it. The first stage is where they kind of vet and check to see if the matter amounts to what should be sent to the judicial review, because the judicial review by the courts only deals with decisions made by public entities, public bodies, and public officers, as well as the laws that pass in Parliament to determine whether or not they are constitutional. In terms of the decisions, what the judicial review will do is to say whether or not the decisions that were made by these public officers, including the Integrity Commission, was lawful. Was it according to law? Was the process that they followed a process that they should follow according to law, and whether it was fair? So that is where we are. So in our first narration of the ruling of the court in the first segment as to whether or not the application for judicial review should be approved, right? That's what this judge is supposed to determine. So we're reading her reasons, what it is that she approved to go forward, and what she says should not go forward. Now, you may ask, what would happen if she decide that it should not go forward? Well, it does not. They will only argue the point that she approved. If your next question is, what would happen if Holness wins? Well, that now is what we are going to find out. And we were at paragraph 15, so we're going to continue now. But we're going to begin at paragraph 14, the end of it, at the top of the page. And they're speaking about the judge and what test that she is to use to determine whether or not to grant the approval for Holness to submit an application for judicial review. Remember, this is the first stage now. And at this stage, the judge is going to look at his application and see if he qualify to go forward. Basically, that's the long and short of it. Great. So the judge was giving a background to a case, and the judges in that case made certain rulings, and this is where we are now. So it says here that the test to be applied is the usual test for the grant of leave for judicial review. The threshold for the grant of leave is low. This is what the Privy Council said. The board is concerned, and the board, by the way, is the Privy Council. That's what they call themselves. So the board is concerned only to examine whether the respondent has an arguable ground for judicial review, which has a realistic prospect of success. Wider questions of interest, of public interest, may have some bearing on whether leave should be granted, but the board considers that if a court were confident at the leave stage, which is a permission stage, that the legal position was entirely clear and to the effect that the claim could not succeed, it would usually be appropriate for the court to dispose of the matter at that stage. So what happened here? The attorneys for Andrew Holness had argued that because the case is of public interest, whole heap of people want to know what going on because of the Prime Minister. Therefore, what she should do, or that alone, the fact that me and you interested and other people, that alone should qualify the case to go forward to judicial review. And I reach judicial review yet, It's just at the stage where they're vetting it to see whether or not it should go forward. So he made that comment and quoted two cases, right? Involving some case in Trinidad and Tobago. So the judge can't believe her ears, decided, well, make she go read these case files for herself. And when she read the case file, she found that the Privy Council was actually saying, in fact, that because it was brought up in those cases, that since it was the President and the Prime Minister involved in the Trinidad case, they brought up the matter of, the public interest. And what it is that the Privy Council said was that notwithstanding the fact that the public has an interest, maybe you could take that in consideration. But you see, if when the judge looking at the evidence before her and she sees that the law that they come to dispute is clear, right? And therefore there is no chance of the person who is bringing the claim winning, then what the judge will do is terminate the case at that point. The Privy Council said it would usually be appropriate for the court to dispose of the matter at that stage, right? So, in other words, the public's interest is not to be a consideration. The only thing that is supposed to be a consideration when you're looking at approval for judicial review is whether or not the person who is asking for the review, like Holness, he has to show grounds. He has to show what grounds he's bringing this. He wants to take the IC to judicial review, and he has to come with his evidence to back up those grounds. And then he has to now show that based on the evidence, he has a realistic prospect of winning the case. Basically, that is what that is saying. Great. So let's continue at 50 now, where we had left off. So Justice Althea Jarrett went on to say, turning now to Regina, Gentle, and others, in that case, the English Court of Appeal had before it a claim for judicial review of the Government of England's refusal to hold an independent inquiry into the circumstances which led to the invasion of Iraq. The appellants were parents of servicemen who had died during the Iraq War. The first instance judge, the first instance meaning where they started the case, right? That judge had refused leave to bring the judicial review claim and had also refused leave to appeal his decision. In other words, so what happened was, when they went to the first court, which would be the Supreme Court in England, and asked for a judicial review, because they have to go through the same process, right? They have to make sure that they now come there for waste them time. Because it's not all matters can go to judicial review. Only those things that have to do with government and government bodies and the decision they make and the laws that are passed. You understand? Great. So when these group of people who went to the Supreme Court to ask for what they said it was now, an inquiry, an independent inquiry in the circumstances which led Britain to go in Iraq, what they talk about Saddam Hussein had weapons of mass destruction. He was creating and they found none. Yes. So that judge said, no, allow no to go forward with no review. And so they now took the matter to the Court of Appeal, which is a higher court, to appeal the decision of that judge. You following? Great. So let's continue. The application for leave to appeal was renewed at the Court of Appeal, where that court decided to grant leave for judicial review instead of leave to appeal, pursuant to, and they gave the sections of them civil procedure rules, allowed an applicant to apply to the Court of Appeal for permission to appeal where permission to appeal for judicial review has been refused. Oh, so for them, civil procedure rules, which governs how the court is supposed to operate, those are the rules and procedures. They give the Court of Appeal also the power to permit a judicial review. So if you go to the Supreme Court and that judge refuse, then the Court of Appeal can allow you. You follow? I'm not sure that that is the case in Jamaica, but let me continue. Provided that on an application under CPR 52, the court may, instead of giving permission to appeal, give permission to apply for judicial review. Under CPR 5236 in UK, there are two grounds on which the Court of Appeal can grant permission to appeal. Either A, that the appeal has a real prospect of success, or B, there is a compelling reason why the appeal should be heard. You hear that? So that Court of Appeal now, when you fail at the Supreme Court in Britain, you appeal the ruling in the Court of Appeal, and they now have two grounds on which they may grant the permission. And the chief consideration is whether you stand a good chance, or using their words, you have a real prospect of success, right? And then there's a second one, which they said that there's a compelling reason why the appeal should be heard. Well, I don't have no example for that. So let us continue. See if they provide any example. The court, interestingly, decided that it should give permission to appeal on the basis that the appeal raised important issues around which there was uncertainty, and that this was a compelling reason for the appeal to be heard. So they had made that decision not on whether or not they had a prospect of success, right, but whether or not there was a compelling reason why the appeal should be heard, and they give their reason, as I just read. However, it then decided that instead of granting leave to appeal, it would grant leave for judicial review on the same basis on which it granted leave to appeal. It then proceeded, pursuant to the CPR 52 15.4, to hear the judicial review claim itself. So you see how that the one they set up? I think that's a good way to go, and we probably should do the same here if we don't have it in our law, because it seems as if it cut time. Don't you agree? Let's go on to 17, where it says, it is therefore in the context of the English rules of court as they then stood that Sir Anthony Clark, Master Registrar, I think that is what that means, said the following in the start of the court's judgment at paragraph 1. And they're quoting him. This is an application for judicial review of the refusal of the government to hold an independent inquiry into the circumstances which led to the invasion of Iraq. The application for permission to proceed was originally heard by Justice Collins, who refused it on 20th of December 2005. He also refused permission to appeal, but the application was renewed to this court and adjourned by Lord Phillips of Worth Matravers, CJ, to be heard on notice to the defendants. We heard the application, and on the 26th of July 2006, decided that this was a proper case in which to grant permission, not on the basis that we had concluded that the application for a judicial review had a real prospect of success within the meaning of the CPR Rule 52.36, but on the basis that because of the importance of the issues, there was a compelling reason why an appeal should be heard. And they give another case file. We then considered whether instead of giving permission to appeal, we should give permission to apply for judicial review under CPR 52-15-3, and if so, whether this court should consider the application under CPR 52-15-4. We answered both questions in the affirmative and reserved the application to the same constitution of the Court of Appeal. Now the judge, milady, it seems to me that the English Court of Appeal's decision to hear the claim for judicial review was not based on a modified threshold test which required regard to the public interest. Instead, it was the English Rules of Court which allowed the court to grant leave for judicial review instead of leave to appeal. And in granting leave for judicial review, it did so for the same reason it decided that the appeal should be heard. All right, so now they're going to be discussing now Andrew Holness's application to ask this court permission to apply for a judicial review. And remember what it was that Holness wanted the review for? To have the quashed the decisions and the recommendation made in the report that was tabled in Parliament, the two reports, to force the Director of Information and Complaints to certify or not certify, to examine his statutory declarations for 2022 and 2023, because at the time when they put that before the court, they were under the impression, because he said he had not examined those, so they were trying to get the court to force him to do his job. But by the time he got to court, he told them, yes, he did it. So that was disposed of. And the next one is that they wanted to compel the Director of Investigation to send another report to the commissioner saying that him check things and him change his mind, and Andrew Holness not guilty or not. Basically, that is what that was. And then they wanted orders for holy powder something, which the court eventually made rulings on. But we won't preempt the court. We will continue. So at 18 now, she said what she said, and now we're at the application itself that Holness made. We know the meter it now. Great. So let us read on at 19, paragraph 19. By amended notice of application for court orders for permission to apply for judicial review. That's the title of the document that they had submitted and filed in the court, right? And she said that it was filed on October 17, 2024. So that means that they had filed one before and found that they needed to amend it. So they amended it. And this is the amended one now that she's going to be using to come to a decision. Great. So it says here, the applicants seek the following 28 remedies. So we're going to know what it was now that he had applied for. An order for certiorari, quashing the report and the findings and recommendations of the second and or third respondents. Remember, that would be Kevon Stevenson, the investigator, and the third respondent would have been the Integrity Commission, as being inconsistent with the provisions and procedures contemplated by the Integrity Commission Act. So they must say the court for quash the report itself and the findings in the report with the recommendations, because they never follow the procedure intended by the Integrity Commission Act. That's what I understand that to mean. Next, he was seeking an order of certiorari to quash the said findings, conclusions, and or recommendations made in relation to the applicants, that is Holness and the three companies, by the second respondent, Kevon Stevenson, the Director of Investigation, which are contained in an investigation report dated August 30, 2024, and the third respondent's special report dated the 5th of September, 2024, except the matters that were dismissed by the Director of Corruption Prevention. All right. So they wanted the findings, conclusions, and recommendations. Almost everything, that the report of the investigator that was tabled in Parliament with a special report talking about them should send on the report to the FID. They want that quashed. They want a decision to quash that. Then they want a third quashing order, an order of certiorari quashing the investigation report dated August 30, 2024, and the third respondent's special report dated the 5th of September, and the findings and recommendations of the second and third respondents as being an improper use of and or abuse of the powers and discretion conferred on the respondents under the Integrity Commission Act and the Corruption Prevention Act. So this is more or less asking the court to decide that they had abused their authority in respect to the findings and so on in those reports. So for all of these various orders that they are going to be asking the judge for and the declarations, they are going to be presenting their arguments to the court to show that they had abused their authority, and then the judge now will make a decision as to whether they agree or she agreed, and therefore it should go forward for the other judge to hear the matter. You follow? Yes. So at D now, they ask for now an order of mandamus, which is to compel the first respondent, Craig Beresford, to examine the first applicant's, Andrew Holness, 2022 and 2023 statutory declarations as provided by Section 32 and 42(1) of the Integrity Commission Act. And that was settled because he had gone to court already and told him that he had done it. So that was that. Next, you have an order of mandamus compelling the first and or third respondents, that's Beresford and the Commission, to comply with Section 32 and 42(1) of the Integrity Commission Act in relation to the first applicant's declarations for 2021-2022. The third order of mandamus was to compel the second respondent, who is the investigator, to recommend to the third respondent, the commission, that the applicant, Andrew Holness, be exonerated of culpability in relation to the 2021 and 2022 statutory declarations in such manner as the third respondent deems fit and in accordance with Section 54(5) of the Integrity Commission Act. So Andrew Holness wanted, as we said before, the investigator Kevin Stevenson to write to the Integrity Commission, the commissioners, and tell them, look, we made a mistake, When we check it out, Andrew not guilty or nothing after all. That's the long and short of what they wanted. So those were the compelling orders. They call them the orders of mandamus. Now, they also wanted the court to make certain declarations, which would be the court, saying these things that they want the court to say, having presented the court with the evidence. One, it says here a declaration that the submission of the reports to Parliament, save for the matters referring to the 4 accounts for tabling, was unlawful and or illegal, having regard to the full terms and effects of Section 54 of the Integrity Commission Act. Because we don't know what the evidence presented were, the best thing to do is just to read them all out without comment. And then we'll read later for the clarity as the judge make her determination regarding them each. Great. So let's continue. The H now, it says, a declaration that having regard to the fact that there was no statement of reasonable suspicion of corruption in relation to the matters referred to Parliament in the reports of the 30th of August 2024 and the special report of the 5th of September 2024, and there being no reference to the Director of Corruption Prosecution, the third respondent, who is the Commission, was wrong to submit these reports to Parliament for tabling. So they're saying here that there should have been a statement of reasonable suspicion included in the report, and there being none, they are saying that it should not have been tabled. The third declaration is sought from the court is that a declaration that Section 14.5 of the Corruption Prevention Act, that is the section that deals with illicit enrichment, is unconstitutional and should be struck down insofar as it breaches the presumption of innocence and the right to life, liberty, and security of the person as guaranteed by Section 13.3a of the Charter of Fundamental Rights and Freedoms by the imposition of the reverse onus requiring the first applicant to prove an essential element of the offense of illicit enrichment. Now, if you recall, when we read what the prosecutor said, she said that when Holness gave an explanation about the three accounts, two it boiled down to. His father's account that had his name on it and the constituent account that had his name on it. When he gave that explanation as to how his name came on it and that it is not his account and he does not control the account, he just have his name Kachan. Yes, when he said that, she said the onus now shifted to her to prove that what he's saying is not true, and there was no evidence before her. So, yes, initially, when they have the suspicion and they ask you a question, the reason why they put it this way, for you to prove or you to show that it was not illicit enrichment, is to force you to give them an answer. Because if you don't give them an answer, what the law says is you will be charged for illicit enrichment. So I don't think they will get this one by. I think the law, how it is set up, is perfectly reasonable in my opinion. Don't know about yours, but you can let me know in the comment section. Yes, I'd appreciate that. So the fourth declaration that they're asking the court for is that J, a declaration that Section 14.5 of the Corruption Prevention Act is unconstitutional and should be struck down insofar as it breaches the applicant's due process rights as guaranteed by Section 16.2 of the Charter of Fundamental Rights and Freedoms by the imposition of the reverse onus requiring the applicant to prove an essential element of the offense of illicit enrichment at the investigative stage, which same material provides the basis for the trial of the offense of illicit enrichment and the imposition of penalties under Section 15 of the Corruption Prevention Act. I think what they are saying here is that Section 14.5 forces the individuals to respond. If they fail to respond, they will be charged for illicit enrichment. And what she's saying is that that is unconstitutional. So let me go on. So the fifth declaration sought is that Section 14.5 of the Corruption Prevention Act is unconstitutional and should be struck down insofar as it breaches the first due process rights as guaranteed by Section 16.2 of the Charter of Fundamental Rights and Freedoms, insofar as the role of the investigator and that of the prosecutor have not been decoupled. That is basically saying that the prosecutor is supposed to be doing one function and the investigator is supposed to be doing another set of functions. And they seem to be suggesting that under this particular law, their functions are not separate. Each one of them can interfere in the other one. That is a serious thing if it is so. The next one now is the sixth declaration sought that the respondents infringed the applicant's right to fair procedures or natural justice at common law and due process under Section 16.2 of the Charter of Fundamental Rights and Freedoms due to the impermissible intermingling of or the lack of fairness, impartiality, and independence of the functions of the first respondent, that's the Craig Beresford, the Director of Information and Complaints, yes, the second respondent, the Director of Investigation, and the third respondent, the Commission. In other words, them one another business, and the law does not permit that. That seems to be saying. The seventh declaration sought at M is that the second and third respondents, that's Stevenson and the commissioners, acted ultra vires the Integrity Commission Act in referring or purporting to refer the matter of the second and third applicants for investigation to the Financial Investigations Division. Now, of course, the second and third applicants would be the two companies, right? Two of the companies. And they're saying ultra vires mean, if I recall correctly, outside of the powers that were given to them by the Integrity Commission Act. When them talk about, say, them are going to refer the matter of the two companies to the FID. Remember, it's about Andrew Holness's statutory declaration. So they're saying that the company is not really coming to it, even though he's a director or owner. That's what they're saying. Let's continue now to the eighth declaration. So they are seeking at N a declaration or order that by disclosing the contents or subject matter of its investigation, including the applicant's private information and the fact of its referral or intended referral of the investigation to the Financial Investigations Division, the second and third respondents, that's Stevenson and the Commission, breached the applicant's reasonable expectation of privacy as guaranteed by Section 13.3J2 and 13.3J3 of the Chapter of Fundamental Rights and Freedoms. Now, here they're talking about the disclosure in the reports that went to Parliament and therefore made public that included his account numbers. There were some account numbers in mother and father name, much money in them account and all that, especially in the mother's case where his name was not on her statement that went to them, that he was a joint holder with her. That the one that favor trouble to me. Anyway, the ninth declaration at O, that the applicants were entitled to notice of the decision or to a hearing by the third respondent at common law and or Section 16.2 of the Charter of Fundamental Rights and Freedoms prior to accepting the second respondent's recommendations, including whether to send the report or any part thereof for the consideration of the Director of Corruption Prosecution and or to Parliament, Tax Administration, Jamaica, and the Financial Investigations Division. So they're saying more or less that before the report of the investigator had gone for referral to the prosecutor, they should have called him into a meeting to inform him of their decision. That's basically what I understand that to be saying. The 10th declaration at P said that the second and third respondents, Stevenson and the Commission, acted in breach of natural justice and or Section 16.2 of the Charter of Fundamental Rights and Freedoms, as the applicants, Holness and the companies, were entitled to a hearing at common law and or Section 16.2 of the Charter of Fundamental Rights and Freedoms prior to making recommendations adverse to their rights and interests. I think that is clear. Then at 11? At Q, an order, he's now seeking an order that the investigation by any competent authority should end and or that it would be unfair to continue the investigation in all the circumstances of the case. So they want the court now to order that them put an end to the investigation, given the circumstances that they are saying that Holness's rights were breached. That seems to be what they're saying there. So next we have another order at R, striking down the provisions of the Integrity Commission Act, given the lack of fairness, impartiality, and independence in the exercise of the functions of the divisions and the commission as presently structured. They seem to be implying that the whole thing, the Integrity Commission Act, is, well, not structured properly and it should be struck down. I think that that should be done in the parliament. And they're basically saying it should be struck down because the way it is structured, there is no fairness in it, and there is no impartiality or independence in the way they exercise their functions, is what they seem to be saying there. At S, we have another declaration and or order setting aside the report of the 30th of August 2024 and the special report, that's what was tabled in Parliament, dated the 5th of September 2024 on the basis that the second and third respondents, the investigator and the commission, usurped the functions of the court by unlawfully and or illegally piercing the corporate veil. Now, you would have heard that in Parliament, in the Integrity Commission Oversight Committee, and they had shut it down. And that piercing of the corporate veil appears to be a provision under the Companies Act, where they're saying that the directors and the companies are two separate persons. I think that that is what they mean. But let me check it out for you. So we found a definition. The question that was asked was, what do you mean by piercing the corporate veil? And it says here, piercing the corporate veil is a legal phrase that describes the owners of a corporation losing the limited liability that having a corporation provides them. And what's that limited liability? Meaning that they're only liable to the shares that they have in the company. If the company should lose money or go bankrupt, you can't get more than the assets, liabilities, and the shares that they hold in the companies. You can't go after the personal assets. So when they lose that liability, what happens? It says when this happens, the owner's personal assets can be used to satisfy the business debts and liabilities. This concept doesn't apply only to corporations. However, so when would they normally do that? You see, if you're running a company and the company's funds is supposed to be used for company purposes, the only time you take money out of a company, a limited liability company, is through your salaries, or if you get dividend on the shares that you have in it. If it's a partnership, then of course, you can have drawings, salaries, and also partnership share and all them kind of thing there. But for a limited liability company, it's only when you pay yourself a salary or you pay yourself the dividend from the net profits, that's the only time you're supposed to take money out of it. All the money of the company, therefore, is to be used back into the business, right? Or to invest for the benefit of the business. Now, if you go inside there and you take money and use for your own personal gain, go and buy a house and car, your name and all them kind of thing there, then no, and the company fall into difficulties, then no, that veil may be lifted. But guess what? The only time it can be done so is through the courts. And that is what they seem to be suggesting, that they didn't go to the court to get an order to lift that veil, which is what it seems as if the investigator did when he took the assets or the earnings of the company, because the company now owns the shares, so the dividends and interest and so on of the shares that the company owns belong to the company. And whatever shares that Holness has and the dividend is paid on that and his salaries, that go to him. Except his salaries was paid into the company. So it became a capital investment. So when they took the company's business and added it to Andrew Holness's personal business, they're saying that that is not how it should have been done. And what they did was to illegally, meaning to say they never go to the court to get permission to do so, and that they say no is illegal, and they want the orders from the court saying that is so. And this is, of course, my interpretation. This is what I think is being said there. The 12th declaration that they're seeking is at T, a declaration that the process utilized by the second respondent, the investigator, in conducting his investigation, which resulted in his findings, conclusions, and/or recommendations made in relation to the applicant, which are contained in an investigation report dated the 30th August 2024, was unfair, unreasonable, and irrational. So that now is in support of one of the grounds they want to satisfy the court that permission should be granted for the judicial review. And they're basically saying that the way he conduct the investigation, the formula he would have used to arrive at his decision that there was somehow possibility of illicit enrichment, them saying that it don't make no sense at all. That's my understanding of what they're saying there. The 13th declaration sought at U says a declaration that the first applicant's legitimate expectations that the second respondent, the director of investigation, would have observed the principles of natural justice and procedural fairness in conducting its investigation was breached. And finally, a declaration that the investigation findings, conclusions, and/or recommendations made in relation to the applicants by the second respondent, Stevenson, which are contained in an investigation report dated 30th August 2024, were made in breach of the principles of natural justice and procedural fairness. And then he asked for damages for breach of privacy, including stigma damages, because people call him thief, damages for negligent investigation, aggravated damages, vindicatory damages, and they also ask for costs. And that, I suppose, made up the 28 remedies sought. So I suppose we'll take this 4 out, and that would leave 24. Now, let me tell you what I think is going on here. The court made an order about the quashing orders, right? Remember, the 3 of them were allowed. She allowed for the quashing orders. She did not allow for the compelling orders, which would be to compel the investigator to write to the commission and exonerate Holness. They didn't allow that. And the Director of Information and Complaints, Craig Beresford, he had already examined Holness's 2022 and 2023 declarations, so there was no need to proceed there. So what Holness got was the quashing orders. Now, why was it then that the court did not allow the other 18 declarations and orders sought? Why? Because if you look at them, they were really talking about the breaches of Andrew Holness's constitutional rights, and they wanted parts of the laws to be struck down, and therefore that has to be taken now to another court. You don't need permission to carry those matters to the court. That's what the judge said. Why? Because you have the constitutional court that would adjudicate on those matters. You follow? Yes, so they took the matter to the wrong court. So it's for Andrew Holness now to take the matter that has been excluded to the constitutional court, and then they will deal with the matter there. So at this point, we're going to take our second break to have a bite to eat. And for those of you who need to stretch your legs, please go ahead and do so, and then you can rejoin us. All right? So catch you guys later.